everyone, and welcome to our 30-minute mini webinar, State and Tribal Responses to the Vaping-Related Health Crisis. I'm Carrie Cork, Senior Staff Attorney at the Public Health Law Center, and I'll be moderating today. As you know, reports of vaping-related lung injuries and deaths are increasing every day. This webinar will be a brief state-by-state update on strategies used to respond to the outbreak of vaping-related health problems and widespread e-cigarette use, as well as considerations for best practices moving forward. Our speaker today is Jessica Gross, an attorney at the Public Health Law Center. The center is a national network of legal centers and attorneys that support public health and commercial tobacco control policy at the local, state, and national levels. Founded in 2000, the Public Health Law Center is located at Mitchell-Hamlin School of Law in St. Paul in the traditional homelands of the Dakota people. We offer free legal technical assistance to communities, public health advocates, and other partners around the U.S. in several ways, through legal research, policy development, implementation, and defense, and a wealth of publications and resources, which are all available on our website, publichealthlawcenter.org. We also do presentations, trainings, and webinars such as this one. We don't represent clients in court, and we don't lobby. Finally, the Public Health Law Center is committed to the principle that good health cannot be achieved without addressing health equity. Health equity means that everyone has access to the resources they need to improve their own health and maintain healthy outcomes. This means removing avoidable differences between groups of people, as well as overcoming and removing barriers that infringe on fairness, human rights, and environmental justice. Our webinar speaker today is Jessica Gross, a staff attorney at the Public Health Law Center. Jessica provides legal technical assistance to public health professionals and advocates working on commercial tobacco control policies throughout the United States. Prior to joining the Public Health Law Center, Jessica led the Agricultural Worker Project at Southern Minnesota Regional Legal Services, where she provided legal representation, education, and outreach to agricultural workers to help improve their working and living conditions. She also served as a farm worker attorney at the Oregon Law Center and Legal Aid Services of Oregon, as well as a faculty immigration advisor and equity consultant at North Dakota State University. So with that, I'm going to turn the podium over to Jessica.
All right, thank you, Carrie, for that wonderful introduction. As Carrie mentioned, the focus of this webinar today is the response to the current vaping health crisis. So we are going to start with an overview of what is happening right now with the vaping health crisis. Then we will turn to state and tribal actions in response to the crisis. And then inevitably the litigation that has come about challenging the state action. And finally, we will finish with considerations and best practices as we move forward to address the vaping health crisis. So most of you who are listening in today are probably well aware that we currently have a vaping-related health crisis in the United States. Certainly you probably have seen media surrounding vaping-related lung injuries and death. So as of October 22nd, the last time to my knowledge that CDC updated this information, there are currently 1,604 cases of vaping-related lung injuries in the United States. That includes all states except for Alaska, the District of Columbia, and one U.S. territory. There also unfortunately have been 34 vaping-related deaths so far. This information is typically updated on a weekly basis. The CDC has reported that the median age of deceased patients is 49, but there's a wide variety of age groups being affected from 17 to 75. The investigation for the cause of these lung injuries and death is still underway, and the exact cause is still unknown. This next slide shows the use of tobacco products from 2011 to 2018 by high school students in the United States. I'll have you focus on the part of the chart that addresses e-cigarettes. As you will see in white, in 2011, the use of e-cigarettes by high school students was not very high. But if you look at the bar in black, which represents 2018, the use of e-cigarettes by youth in the United States, high school students, there certainly has been an increase in use. Here, the bar that is in red shows the projected use of high school student use of e-cigarettes in 2019. So as you will see, there's an explosion in use from 2011 to 2019. This information comes from the National Youth Tobacco Survey. Here you will see more information from the same survey that shows high school e-cigarette flavor preference. Flavors has gone up quite substantially from 2017 to 2019. Many studies have shown that youth are particularly interested in flavored products when it comes to vaping product use. So now I'm going to turn to the particular actions by states in response to the current health crisis, including both the explosion in youth use of e-cigarettes and the current vaping-related lung injuries and death. So the way that I organize this is I'm going to speak state by state in accordance with which state took action first. So Michigan was the first state to come forth with potential action to address the vaping health crisis. The action that they took is that they promulgated emergency rules by the Michigan Department of Health and Human Services. The coverage of the rules includes flavored tobacco vaping products. So it doesn't cover marijuana rather, but only tobacco. And they include menthol in the flavor restriction. It includes both online and retail sales, as well as the offer for sale, giving, transportation, and distribution of tobacco vaping products. This restriction was to remain in effect for 6 months with the potential of an extension of 6 months. However, as I will go throughout this webinar, this vaping product ban is not currently in effect due to ongoing litigation. Next, New York also brought forth emergency regulations to ban certain vaping products. Their ban covered flavored vaping products as well as menthol. At first, they did not have menthol included in their potential ban, but after recommendation decided to include menthol. This ban is also currently not in effect due to ongoing litigation. The next state that took action was Massachusetts. Again, they enacted an emergency regulation brought forth by the Massachusetts Department of Public Health. Massachusetts has the broadest ban in the United States. So their ban covers flavored and non-flavored vaping products, which necessarily includes menthol products. It covers tobacco, THC, and CBD, and it restricts both online and retail sales. The current duration of this ban is 3 months, and unlike other states, the ban in Massachusetts is currently still in effect. But like all the other vaping product bans, it is subject to ongoing litigation. Next, Rhode Island also brought forth emergency regulations by the Rhode Island Department of Health. The coverage here covers tobacco vaping products, including menthol. Its coverage is a bit broader in the activity that it restricts. It restricts manufacture, distribution, sale, and offer for sale of flavored tobacco vaping products. The duration of the ban is 120 days. There's the potential for an extension of 60 days. This ban is also still currently in effect, but again, is subject to ongoing litigation. Washington also has emergency rules in place by the Washington Board of Health. It covers flavored vaping products, including menthol. Unlike some other states, it covers both tobacco and marijuana. And again, it covers online and retail sales. This ban will be in effect for 120 days. And it also is still currently in effect, but it's subject to ongoing litigation. Utah also has emergency rules in place banning certain vaping products brought forth by the Utah Department of Health. Again, it bans the flavor of vaping products, flavored vaping products, including menthol. One exception or change or difference with the Utah ban is that it only applies to general tobacco retailers, which are defined in the emergency rules brought forth by the Utah Department of Health. Therefore, there are still some retailers that can sell flavored vaping products. The duration of this ban is 120 days. And this ban is not currently in effect due to ongoing litigation. The structure in Oregon is a bit different. There were temporary rules that were promulgated by both the Oregon Health Authority as well as Oregon Liquor Control Commission. These rules cover flavored vaping products, including menthol, tobacco and marijuana, and online and retail sales. The reason that there are rules brought forth by both the Oregon Health Authority and Oregon Liquor Control Commission is because those agencies have different power or jurisdiction over different products. So Oregon Health Authority has jurisdiction over tobacco products and medical marijuana, whereas Oregon Liquor Control Commission has jurisdiction over other marijuana products. The duration of this ban is 180 days. And in the course of litigation right now, the Oregon Health Authority ban is not currently in effect. So the rules pertaining to tobacco products and medical marijuana are blocked, but the Oregon Liquor Control Commission rules are still in effect and have not been blocked in litigation. In Montana, emergency rules were promulgated by the Montana Department of Public Health and Human Services. The Montana rules cover flavored vapor products, including menthol, tobacco, THC, and CBD, and they also restrict a wider variety of activity, including online and retail sales, offer for sale, giving, distribution, and transportation of flavored vapor products. The duration of this ban is 120 days, and again, it is not in effect due to ongoing litigation. So these slides pertain mainly to the vaping bans that are in place in response to the vaping health crisis. However, some states have taken action beyond vaping bans to address the crisis. So one example would be that in Oregon, the governor also directed certain state agencies to develop legislative proposals to respond to the vaping health crisis and also to create a vaping public health work group. So as you've heard me mention, there is litigation that is affecting the status of these vaping bans. As of today, I should mention that all of this is very much a moving target, so it's changing constantly. But as of today, I believe there are at least 12 lawsuits that were brought forth against the vaping bans that are currently in place. So there is at least one lawsuit in each state that I just addressed that is pursuing an emergency or temporary vaping product ban. And the claims that are being brought forth really vary. There are constitutional challenges, for example, related to the First Amendment or to the Commerce Clause. There are challenges based on federal preemption. And there are also some cases that assert claims based on improper procedure or violations of the State Administrative Procedure Act, for example. So as I mentioned, there are only currently 3 vaping product bans that are in effect. Those are in Massachusetts, Rhode Island, and Washington. Other states that do not have bans currently in effect, those bans are blocked by temporary restraining orders or preliminary injunction. So California has also taken action in response to the vaping health crisis. The reason I did not include it with the other states is because the action that it took in response to the crisis is a bit different. No emergency rules were enacted to respond to the vaping epidemic. Rather, the governor issued an executive order that directs a variety of action. 2 examples of that action is initiating a digital and social media campaign for educational purposes focused on youth and parents to address vaping health harms. And then also there is a directive to develop recommendations to decrease youth access to vaping products. States are not the only entities that have responded to the vaping health crisis. There has also been tribal action. One particular ordinance covers all vaping products and a wide variety of activity, including manufacture, sale, distribution, purchase, possession, and use of vaping products. One difference between the state action and this tribal action is that this is a permanent ordinance. So it is not temporary, it doesn't have limited duration, it is permanent. There have been some other actions in response to the vaping health crisis, for example, by corporations. There are various corporations that have decided to pull e-cigarettes from their shelves. So I wanted to end with talking about what we have learned so far and what would be some best practices moving forward as we address the vaping-related health crisis. So some obvious disadvantages to the state activity so far is that obviously using emergency rulemaking is not permanent, it's not a permanent solution. All of these emergency or temporary rules are limited in duration. And as I just mentioned, there is a lot of litigation happening in response to the emergency or temporary bans on vaping products. As I mentioned, there is at least one lawsuit in each state that is against these bans. There certainly are also disadvantages in approaching tobacco product flavors in a piecemeal manner. So for example, if there were states that were pursuing temporary bans that did not include menthol, as you saw from the chart, youth are very interested in using flavored products, and the preferences for mint and menthol are increasing. So therefore, if there was a temporary ban in place that did not address menthol, it's possible that youth would move to menthol vaping products. Additionally, even for the bans that are addressing flavored products, including menthol, it's always possible that youth would transition to other flavored products such as menthol cigarettes, which are lawful in many jurisdictions. So in terms of best practices moving forward, as I mentioned, any sort of activity that does not contemplate all flavors could lead to unintended consequences in which youth simply transition from one flavor to another or from one product to another. And additionally, I wanted to point out that as states decide what is best, we recommend that preemption is avoided so that local jurisdictions have the power to bring forth policies that are health and community focused on their particular communities, and policies that can go beyond state law. So we have been following the vaping bans as well as the current litigation for the past several months. And so I wanted to direct you to our website, in which we have a publication that is updated regularly that tracks the bans and the litigation. All right, we're going to turn it over to questions now.
Okay, thank you very much, Jessica. That was a very timely and valuable presentation. We do have a few minutes for questions, and I see we've got one here about asking what emergency options other than legislation do states have to address the vaping health crisis?
Sure. So really the state activity so far, rather the temporary state activity so far has been dictated by authority available under state law. So there are a variety of ways in which states may have authority to take emergency action. One source of potential authority is gubernatorial authority to act if there is an emergency or disaster. Based on my review of certain states that have this authority in place, normally a governor's exercise that authority to respond to natural disasters, for example. And there aren't many examples of governors using this authority, for example, to address a public health crisis. There also certainly is the possibility of authority for agencies to enact temporary rules through emergency rulemaking procedures, which is what we discussed today. The states that have taken action have used emergency rule authority under their State Administrative Procedure Act. And that's why oftentimes there's limited duration, because the limited duration comes from emergency rulemaking under state law. Additionally, there's at least one state that we found that had the potential to use injunctive authority by the state's Department of Health to seek injunctive relief to respond to public health crises. So for example, in that state, the commissioner of the Department of Health could seek injunctive relief to declare a public health nuisance. Of course, that avenue is a bit different from enacting temporary or emergency rules, because you would need to go through a court process.
Okay, thanks, Jessica. Do you have any information about the Trump administration's proposed plan to ban all flavored e-cigarettes?
Sure. So that is mentioned briefly on the publication that was on the last slide. So on September 11th of this year, an announcement was made that action would be taken on a federal level to address the vaping health crisis. My understanding is that the FDA has sent its guidance to OMB, but is still at OMB right now. There also have been various media reports surrounding what the potential federal action will be. Originally, the messaging was that the ban would encompass flavored products, including menthol, but more recently, there have been some news stories saying that perhaps menthol won't be included in the action taken on a federal level.
Okay, we have a question. Considering the ongoing litigation with state bans, is it possible that a lawsuit could be filed against the Ogallala Sioux Nation for taking action?
So I think that would really get into federal Indian law, which is certainly not my wheelhouse. That is something that I think that we could look into and discuss with interested parties. But I think the takeaway message so far has been that, at least with the temporary and emergency bans, they have been met with litigation. So I should point out that the tribal action is not temporary. It is a permanent ordinance. And so for example, the claims that have been brought forth against temporary bans, that there have been violations of necessary procedures, for example, due to emergency rulemaking, that wouldn't come into play with tribal action so far.
Okay, I think we have time for one more question. What is, quote, offer for sale, quote?
Sure. So, so sale would be like the actual action of selling. Offer for sale would be, for example, it could potentially be that banned products are displayed. So they are being offered for sale, even if they weren't actually sold.
Okay, great. Well, we are out of time now. We'll do our best to address any questions we received and were unable to answer today. For ongoing updates on state and tribal reactions to the vaping health crisis, please do visit our website at publichealthlawcenter.org. Thank you all for attending our webinar, and have a good afternoon.